Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to talk about how most married couple estate plans use, call it what you want, spousal trust, AB trust, bypass trust, QTIP trust. I'm going to call it spousal trust from here on out. But most married couple estate plans use these spousal trusts that in many cases can be unnecessary while causing administrative headaches and additional taxes for the family. All right, a quick history lesson. Let's look back to pre-2011. Let's call it 2000. Let's look back to 2008 when the estate tax exemption was lower. In 2008, it was $2 million. Now it's $13.99 million. And back in 2008, we didn't have this concept of portability. Portability of the estate tax allows the surviving spouse to use any unused portion of the first spouse to die's federal estate tax exemption. So what portability does, it potentially doubles the amount that a surviving spouse can pass on to heirs estate tax free. Now, using a spousal trust, again, also referred to bypass trust, AB trust, credit shelter trust, QTIP trust, using that trust back in 2008 was mandatory to avoid losing the exemption of the first spouse to die. So the result was that attorneys built these trusts into almost every married couple estate plan. Let me give an example. Let's say back in 2008, when the exemption was $2 million, you had Fred and Ginger. They had a combined estate of $4 million. So Fred owned $2 million and Ginger owned $2 million. 99.9 times out of 100, that estate plan was set up so that when the first spouse dies, let's say Fred died first, his $2 million goes into a trust for Ginger, and then when Ginger dies, those assets revert back to Fred's intended heirs, let's say his children. And the reason that was done 99.9 times out of 100 was that we didn't have this concept of portability. So by Fred leaving his assets to a trust, Fred used his $2 million exemption by leaving his assets to a trust. And then after Fred died, Ginger owned her $2 million that was in her estate. But those assets that Fred left to a spousal trust were not included in Ginger's estate. And so when Ginger died, she only had $2 million in her estate. So Fred used his exemption, Ginger used her exemption. That was how married couples could leave $4 million to their family, even though the estate tax exemption was only $2 million. So what changed? Well, the rise of portability and higher estate tax exemptions. Portability was made permanent in the year 2013, and the estate tax exemption for 2025 is $13.99 million. And now with portability, it's pretty simple for married couples to shield 2 times the estate tax exemption from the estate tax. So really married couples, pretty easy to shield 28 million, 13.99 million times 2, 28 million from the estate tax. So most families just won't owe estate tax. So these complex structures of when the first spouse dies, having to go through the administrative difficulty and losing the step up in basis when the surviving spouse dies, having the assets of the first spouse die go into a spousal trust for the surviving spouse, these complex structures just really often aren't needed anymore. The problem, though, is that outdated plans are still being used because many wills and revocable living trusts default to this spousal trust language. Why did they do that? Attorneys using old templates, attorneys stuck in the past. But for many families, these spousal trusts create unnecessary complexity. So, for example, when Fred dies, now, Ginger has to split all of the financial accounts, move half the money into the irrevocable Fred Trust account, and then move half of the money into the Ginger Revocable Living Trust account. So that requires some administration. It also causes some complexity, and it causes a loss of step up in basis when Ginger or the surviving spouse later dies. Those assets that Fred left to a spousal trust don't get included in Ginger's estate, so they don't get another step up in basis when Ginger dies. So it's more hassle for the surviving spouse. Now, I will say spousal trusts can and still do make sense for high net worth couples, couples with maybe $30 million plus. They make sense for blended families. If Fred had his own 2 children and Ginger had her own 3 children, then it makes perfect sense for Fred to leave his part of the estate to a spousal trust for Ginger. If she needs those assets, she can use them for her needs. But when Ginger died, what's left of Fred's assets must revert back to Fred's children. So that spousal trust in the blended family situation also often protects the heirs of the first spouse to die. So there are situations where these spousal trusts are very valuable. And also perhaps if you do live in one of those few states that has a state level estate tax and there is no portability. So really what I'm getting at here is spousal trusts, again, often referred to as QTIP trusts, AB trusts, bypass trusts, credit shelter trust. They're still commonly found in the last will and testament of a married person, or in the revocable living trust of a married person, or in the joint revocable living trust of a married couple. These trusts are commonly found in wills and trusts, often by default, because they were once a near universal feature of estate planning. Before the advent of portability and the dramatic increase in the federal estate tax exemption, these trusts were essential tools for preserving the estate tax of both spouses. But if a couple failed to use both spouses' exemptions through trust planning, they risk losing one of the exemptions entirely. So as a result, spousal trust became a standard part of nearly every married couple estate plan. However, in today's landscape, with the exemption now high enough that most families are not subject to the estate tax, and with portability allowing any unused exemption to pass to the surviving spouse, these trusts are often unnecessary and can even create administrative burdens and unintended tax consequences. Yet many attorneys and clients continue to include them just out of habit because of outdated templates, rather than using them for actual needs. So the idea here is, so many people tell me, Paul, we did it this way because that's just what the attorney told us to do. But the key here is really getting the information and the education so you can balance the pros and cons of leaving assets to a spousal trust versus leaving them into the estate of the surviving spouse. So the pros of the spousal trust is it avoids that remarriage risk. Fred dies, he leaves his assets to a trust, and then when Ginger dies, those assets automatically revert back to the heirs of Fred. So that avoiding the remarriage risk is a pro of the spousal trust. The cons of the spousal trust are it creates a bunch of administrative burdens after the first spouse dies, and the assets in that spousal trust don't get another step up in basis when the surviving spouse dies, causing the kids to have to pay sometimes significant additional capital gains tax when the kids start selling assets after the surviving spouse passes away. Now, the pros and cons of leaving assets into the estate of the surviving spouse are, the pros are it's simple. Oftentimes, if the married couple has that joint revocable living trust and it just remains revocable by the surviving spouse, there's nothing to do after the first spouse dies. No accounting, no breaking out of the assets. The surviving spouse just continues managing everything for their own benefit. And then the other pro of leaving everything into the estate of the surviving spouse is all of the marital assets get that additional step up in basis when the surviving spouse dies. And then the con of leaving things into the estate of the surviving spouse, that's that remarriage risk where potentially the surviving spouse could change the ultimate disposition plan as to what happens to those assets after the surviving spouse dies, perhaps cutting out the intended heirs of the first spouse to die. So you've got to take that all into consideration. These are really important decisions that married couples often overlook. Hope that helps. We'll see you next time.